behalf of the state. All right, there were objections filed by both defendants in this case. Let's see who would argue in response. Mr. Archibald?
Yes, Your Honor.
All right, Mr. Archibald, on behalf of your client, what's your response?
May I remain seated?
You may, thank you.
Typically, I would agree with the state to sequester a jury during a high-profile case like this. My concern and why I filed the objection is just due to the duration of the trial. Having a jury sequestered for over 2 months with no contact with home, no contact with children, is going to limit our jury pool. Our jury pool is going to consist of who? Retirees, no one with a job, and no one with a business to run. It's going to limit our ability to pick a fair and impartial jury that represents a cross-section of the community. And so that's our concern. I share the concerns with the state about the publicity, about the jurors being hounded by the press. That's a legitimate concern. But I think that it's, with a 2-month trial, asking them to stay away from their home life for a 2-month period of time is burdensome and onerous on them. So we also agree this is a matter of discretion with the court, and I think the court had in mind the transfer of venue in anticipating that if we did change the trial location from Fremont County to Ada County, that the jurors would be able to go home and they would be able to carry on their life rather than put everything on hold for 2 months. So that's why we have respectfully objected to this motion. We do see the state's point of view, but in ours, we'd rather have a jury that represents the cross-section of the community rather than the alternative. That's why we respectfully object.
Thank you, Mr. Archibald. Mr. Pryor, would you like to offer any argument on the motion?
Permission to remain seated?
Yes.
Judge, I think I touched on this in my brief about the statistics and how imprisoning a pool of jurors during a lengthy trial most frequently results in a conviction based on the fact that we are taking people for what's going to amount to 10 plus weeks away from their family, away from their daily routine, and asking them to serve and in a very isolated and singular purpose to listen to evidence day after day after day and be locked up and taken away from their families. That's going to have a financial burden on the jurors. Some of these jurors in Ada County are going to be people who are relying on their incomes to work, their family members, and do things on the weekends to help support their family in any way they can. What you're basically doing is saying 5 of those 7 days you're going to be in front of a jury or be in front of a judge and listen to testimony. And then on the weekends, by the way, if we lock you up, you're not going to be allowed to have furloughs to see your family or maybe earn additional income to help supplement the income that you're going to lose as a result of being locked up. This is incredibly burdensome. The idea of avoiding the publicity was the very reason, and this court was incredibly detailed in your order. You took the time and you drafted an order that specifically noted that the overwhelming amount of publicity in Fremont County, and that we're going to Ada County to draw from a bigger pool of people. We can't get around the fact that there is publicity. And I trust that the Ada County Sheriff, in conjunction with the Fremont County Sheriff, are going to be able to provide adequate amount of security for the witnesses. But the fact of the matter is, Judge, is that even if the jury was sequestered, the press and some of these folks will have access to the witnesses, and they may do that anyway. You're not going to sequester witnesses. And the reality is that the only thing you're doing is stopping a bunch of jurors from maybe reading some papers and getting on the internet. And you can instruct them about that, Judge. That could be done with an instruction. And quite frankly, the the overwhelming burden that you're going to place on these jurors because the state is concerned about the publicity, it doesn't equal itself. The reality is that the cat's out of the bag. Everybody in the world knows about this case, and there's not going to be any changing that. And we are going to go through a significant process that this court has outlined in terms of coming up with a jury questionnaire that's going to alleviate some of that. And I trust that the court's process is going to help allow us to come up with a jury that we do not need to lock up and impose a two-month plus prison sentence on.
All right, thank you. Ms. Smith, any rebuttal argument?
Your Honor, just briefly, in terms of no contact with home, no contact with children, the cases that I've done, and in Missouri, they have to be sequestered for the trial. There is a process by which jurors are allowed to contact their family. There's a process by which they have communication with family and children. And so there are some things to mitigate the hardship. However, given the stakes in this case, given what the state is asking for, and given what happened to these children and to Tammy Daybell, we think this is a situation that merits it.
Thank you, Ms. Smith. The court has considered argument on this issue. I'll note that had some time to think about the issue. Obviously, the motion was filed September 29th, 2021, so since it was brought up and since the court ordered the transfer of venue for trial to Ada County, I've done a significant amount of investigation on this issue, including discussions with Ada County on procedures that could be implemented. Certainly there's a balancing to make on both sides of this issue. On one hand, ensuring jurors are not exposed during the course of the trial to information which could end up disqualifying them can be best obtained likely through sequestration because of the control already in place, and the balance there made with share some of the concerns Mr. Archibald raised about hardship at places and whether or not you come up with a fair cross-section of society that's able to serve if that sequestration were to be placed into effect. Courts consider that in terms of the schedule of trial. Most importantly, looking at plans that can be implemented while the case is tried as it relates to jurors' anonymity, jurors' security, affidavits that jurors would be required to submit to declare and testify under oath that they haven't gone and done something if they are not in trial to result in their disqualification. And upon balancing all that, and I'll point out also, while there are cases involving prior cases, jurors that were tampered with because they weren't sequestered, there's also instances, probably most famously in the O.J. Simpson trial, where jurors start to go so stir-crazy when they're sequestered that there becomes what they call a juror revolt, and in that case one day they all just said they're not going to trial anymore. So somebody had to talk them down and keep the trial going. So the psychological impact can't be overlooked also of that issue. Clearly, as mentioned by the state, if the case goes into a penalty phase, then sequestration is required by statute. It's discretionary with the court before that phase whether or not sequestration should be implemented. The court considers the statute under Idaho Code 1918-16, and in weighing out the balancing here, the court does determine at this time that I believe adequate steps can be put into place to not require sequestration during the course of the trial, and of course the court will take those steps very seriously and admonish very seriously the jurors but I believe given the duration of the trial, that's the main concern. We stand less of a chance of losing jurors during the course of that trial, I think, if they are not sequestered for such an extensive time. So based on all those considerations, and the time filing was made also, there was a reference to whether or not we should consider COVID concerns in terms of sequestration also. I've looked at those factors and in my discretion determined at this point that sequestration is not going to be required during trial for the jurors. Of course, again, if it goes to a penalty phase, then a sequestration would occur for that part of the trial as it's required by statute. So, those reasons I've stated on the record here, I'm denying the motion to sequester the jury during trial.
Thank you, Your Honor. May I make one request? The court indicated that there were going to be steps determined to help protect the jurors. May we ask that when the court and or the sheriffs determine what those steps are, that the parties be given them simply in the event of, for example, if there's an order that the jurors' names are all sealed and remain anonymous. We would want to, all the parties would want to know that because we want to make sure that we don't inadvertently give it to a jury consultant or, there's some reasons why the parties would want to know some of the court's limitations so that we don't, as officers of the court, inadvertently violate those. So that's my only request is once there's a plan, if the parties could just know what that plan is, that will help us make sure we and our people follow all the requirements.
Okay.
Thank you.
That issue is it's an administrative issue to the extent that it would affect parties and that they have that information required to comply. The court will provide that information. Otherwise, the court will, of course, not be disclosing the plan that would be implemented because the point of the plan is to keep
Yes, understood.
So I'll keep that concern in mind.
Thank you.
All right. Any questions on that ruling, Mr. Archibald?
No, thank you.
Mr. Pryor, any questions?
No, Your Honor, thank you.
Record on these matters, case CR 22-21